Good morning and a very warm welcome to the TECSA Annual Adjudication Conference. My name is Andrew James. I'm a partner at HCR Law and currently chair of the Adjudication Subcommittee. I'm sorry we're not being able to do this in person as we normally do just before the annual dinner, but I hope you'll find it a useful and insightful morning. I'll just ask for the agenda to be put up so that we can just remind ourselves of the lineup of speakers this morning. And you'll see that we've got an excellent lineup. And in terms of questions for speakers, please could those be submitted via the Q&A function. The speakers will try to take those at the end of each session. So if you could use that Q&A function, please. I hope you're all well and got through the fog and ice this morning as I did in the Midlands. It's been a strange year, but hopefully today everyone is well and is keeping busy. I certainly seem to be very busy at the moment. A number of COVID-related claims, and one of our speakers, Zoe, will be talking about that later. I'm just waiting for a minute or two for everyone to join. We've got about, say, about 180 people booked to attend this morning, so we'll just wait a minute or two for everyone to join. I can see that the participants' numbers are starting to rise. Okay, well, for those who've just joined, again, a warm welcome from me, Andrew James, partner at HCR Law, and welcome to the TECSA Annual Adjudication Conference. As I said, there's the agenda up for this morning and the list of our speakers, and a reminder to use the Q&A function if you wish to ask any questions. I think all our speakers are able to stay for most of the session, although I know Mrs. Justice Farrell has got a busy morning in court, so she will need to leave at 9:30 or thereabouts. So if you have any questions for Mrs. Justice Farrell, then please log those via the Q&A function. Before I introduce our speakers, I just wanted to give a quick update in terms of the TECSA adjudication service. And if I could have the next slide, please. So we've had a busy year this year at TECSA, and following the successful piloting of our low-value dispute service, which deals with liquidated claims up to £100,000, we decided to make that a permanent offering on the 1st of January this year. I think I'm right in saying we were the first out of the traps, as it were, in terms of launching that service. I think a number of businesses and individuals have found that useful and an aid to securing cash flow, in particular in these difficult times. So we're very pleased to be able to offer that service. I'd like to thank our panel members who've agreed to deal with LVD schemes. I do appreciate that those are not always the most remunerative of cases. If there's any comfort, I'm on the panel of LVD adjudicators as well. So I practice what I preach, but that seems to be working reasonably well. In terms of some statistics for the year, we've had 177 cases, of which 125 are non-LVDs and 52 which have been those low-value disputes. And that represents an increase in the number of cases we are dealing with. In 2018, we had 146 adjudications in total, and in 2019, we had 151. So quite a steady increase in the number of adjudications we're dealing with. I'd like to thank Caroline Pope, our chairperson, who has the unenviable task of dealing with the appointment of adjudicators. That's a pretty big job. Other committee members help out with his conflicts, etc. But it is a very busy time for Caroline and her team at DLA. So I'd like to publicly thank them for all they do. In terms of the panel, we currently have 72 adjudicators on the panel, and we do continue to offer a multidisciplinary service in the sense of having a mixture of barristers, solicitors, quantity surveyors, engineers, planning programmers, and architects, amongst others. So perhaps contrary to what some people think, TECSA is not just a panel made up of lawyers, and we do offer a broad service to the sector. We've had some retirements this year, and sadly Dennis Baldwin, who some of you may know, passed away earlier this year, and our condolences to his family. We have appointed some new adjudicators to the panel, and I'm pleased that we've got 3 new women adjudicators to the panel: a dual qualified architect and barrister, a dual qualified engineer, barrister, and solicitor. And whilst we'll always select on the basis of quality and expertise to get on the panel, we will, wherever possible, endeavour to make our panel more representative. In terms of this morning's session, shortly I'll hand over to our keynote speaker. Just a reminder for those who've joined in the last minute or two to use the Q&A function to ask any questions, and those questions will be taken by each speaker at the end of their respective sessions. It now gives me very great pleasure to introduce our keynote speaker, the Honourable Mrs. Justice O'Farrell, DBE. Many of you will know Finola, a very distinguished barrister at Keating Chambers, and was called to the bar in 1983 and took silk in 2002. Finola has become the judge in charge of the TCC, and she's very kindly agreed to speak to us this morning about justice in lockdown, and also to touch on an important recent case. Over to you, Finola.
Good morning, everyone. The biggest impact on adjudication enforcement in the courts this year has been, of course, COVID-19, and in particular, the lockdown that has prevented most hearings from going ahead in courtrooms in person. CPR 39.21 provides that the general rule is that a hearing is to be in public. A hearing may not be held in private, irrespective of the parties' consent, unless and to the extent that the court decides that it must be held in private, applying principles such as the interests of a child or national security, or the nature of the application, for example, an urgent injunction. CPR 39.2(2)A provides that the court shall take reasonable steps to ensure that all hearings are of an open and public character, save when a hearing is held in private. You may have forgotten this by now, but things moved very, very quickly back in March 2020. As at the 17th of March, the approach that was being taken by the courts was to keep calm and carry on. And that was a quote. But of course, we all know that by the 23rd of March, lockdown had been announced, changing many of our working practices, possibly for good, but certainly for a significant period of time. On the 23rd of March, the day on which lockdown was announced, the TCC issued template orders and letters providing for remote hearings, including remote adjudication enforcement hearings. And in fact, on the 23rd, I had my first remote court hearing in order to deal with parties who were isolating. The courts were very swift to adapt to the new situation. During the course of that week, the Coronavirus Act was passed and the coronavirus regulations were introduced. The courts introduced a new practice direction, 51Y, providing for video hearings. And by the end of that week, there was a protocol for remote hearings for use across all jurisdictions of the High Court. So within the period of 1 week, the practice in the TCC had been transformed. Inevitably, there was a challenge in the courts to the progress of adjudications during lockdown. In April of this year, a case called Milchrist and Waters came before Mrs. Justice Jefford by way of an application for an injunction to stop an adjudication that was then in process. The claim was that the COVID-19 crisis meant that the adjudication couldn't be conducted fairly and in accordance with the rules and principles of natural justice. The judge refused the injunction. She decided that papers could be delivered electronically or otherwise. A site visit could take place, if necessary, by the adjudicator without others present, and instructions could be dealt with by the parties on a remote basis. So the courts were swift to decide that the COVID crisis and lockdown did not necessarily need to halt the business of adjudication. And the courts indicated that they would support adjudication business as usual or as near usual as could be achieved. The impact of COVID-19, the lockdown and the restrictions on adjudication enforcement have been relatively limited in terms of progressing the business of the courts. There were a small number of hearings that had to be adjourned for COVID-19 reasons, usually involving NHS providers or where people were isolating and didn't have access to the paperwork or to visit a site, and that was necessary for the purpose of the hearing. That's more particularly relevant perhaps for Part 8 hearings than adjudication enforcement strictly. But in most cases, the hearings simply went ahead as originally listed, save that the hearings were remote, usually remote video link hearings. There were some exceptions where, for example, service out of the jurisdiction was required. And certainly there were cases where the parties agreed that there should be a stay of the enforcement hearing or for longer extensions of time. But very generally, the cases simply continued as normal through the crisis. Since the beginning of June of this year, the TCC and the rules building in general has been able to offer either full in-person or hybrid hearings in court. But it is noticeable that many parties and their legal representatives have chosen not to take up the offer of in-person hearings. I should emphasize that the philosophy of the courts is that they will offer in-person hearings but they won't force parties or their legal representatives to come to court at this time. And many have simply chosen to retain their remote hearings. There have been some technical glitches. It took time for everyone to put in place the equipment that they needed and to make sure that they had the right devices and the right cameras and so on for remote hearings. Even today, I'm sure at some point someone will have a technical difficulty. Usually it's an internet connection. But generally, it hasn't interfered with the way in which business has been conducted. Sometimes hearings take a little bit longer because someone has a difficulty with their internet connection or their camera or their audio. But we just have to have a bit of patience. If someone drops out of a hearing, the court simply waits for them to establish an alternative connection. And generally, that doesn't really interfere too much with the running of the hearing. The phrase, "you're muted," has become commonplace in the courts. And I'm sure all of you have experienced similar issues during your remote meetings and other hearings. There has been concern expressed about public access to the hearings. I started by referring to the fact that generally the rule is that there will be public access to the courts. That is of concern. However, the press do have links that they can ask for to every hearing that would normally be in public, including adjudication enforcement. Interested parties can also ask for a link to join the remote hearing. And in fact, for the court reporters, it's actually proving to be helpful to them. They can attend an early hearing in the morning in the Rolls building remotely. They can then attend a second hearing later that morning in Manchester. And then they can attend another hearing in Bristol in the afternoon, because they don't have to travel. They simply have to log in to the relevant hearings. So in some respects, actually there is better visibility as to what's going on in the courts. Concerns have also been expressed about vulnerable parties, those who have learning disabilities, or those who simply don't have access to the right equipment and good internet connections. Certainly there are difficulties across the court system, principally in the family jurisdiction and in some parts of general QB work. But for the most part, in the TCC, actually, it's been helpful for litigants in person. I have been able to hold case management conferences and adjudication enforcement hearings where one party has been representing themselves or their company, and they've actually benefited from not having to leave their home or their office. It's quicker and cheaper for them, and they feel very comfortable dealing with it in that way. I have been very impressed by the flexibility and the resilience that has been shown by everyone involved in the adjudication enforcement process. Obviously the adjudicators in the first place, but also the parties, their legal representatives, the judges and the court staff. All have worked together to ensure that the wheels of justice could keep on turning. So, what for the future? I think that we have now got used to the benefits of technology to improve the efficiency and the cost of legal proceedings without compromising justice. I do consider that this new technology is of particular value to litigants in person who don't have to incur the costs and time of court appearances. For the parties, the managers and directors no longer have to give up a full day of their time in order to attend a hearing of an hour or even less. They can simply log in to the hearing and stay for as much or as little of it as they have time for. Adjudication hearings in particular, where there's little or no evidence and most of it is dealt with simply by submissions, lend themselves very well to remote disposal. The courts recognise the value of retaining physical hearings where appropriate. I have to say I have a personal preference for in-person hearings, particularly if it's a matter of any length and substance. But it has taken a pandemic to demonstrate how change can be introduced across the court system quickly and successfully. And my prediction is that remote hearings for adjudication enforcement are the future. I just want to touch upon a very recent case, a judgment in the case of Halliburton and Chubb in the Supreme Court that was published on the 27th of November 2020. Many of you may already be aware of it from its progress through the courts. It arose out of the explosion and fire on the Deepwater Horizon drilling rig in the Gulf of Mexico, which occurred in 2010. Halliburton provided the cementing and well monitoring services to BP. The blowout of the well caused extensive damage and loss of life. It also resulted in a lot of litigation and arbitration. And in this particular case, Halliburton claimed against Chubb under its insurance policy. The claim was disputed, and so it was referred to arbitration. The arbitrators included Ken Rokerson, QC, a very well-known arbitrator. Before he accepted his appointment, he very properly disclosed that he had previously been appointed and acted as an arbitrator in several arbitrations in which Chubb, the insurer, was a party. That disclosure was made to Halliburton, and Halliburton indicated that it didn't have any difficulty with it. After Mr. Rokinson's appointment in the Halliburton arbitration, he was appointed as an arbitrator in another arbitration by Chubb against a different party, but arising out of the same Deepwater disaster. Before accepting that appointment, Mr. Rokerson disclosed to the parties in the second reference that he had already been appointed in the Halliburton reference. And the parties indicated that they didn't have any difficulty with that. But Mr. Rokinson didn't disclose to Halliburton his reference, proposed reference, in the second arbitration reference. Halliburton subsequently found out and decided to challenge it, and it went to the courts. As I'm sure you're all familiar with, there is a duty of impartiality which applies to a judge, to an arbitrator, and of course also to an adjudicator. It's not sufficient for the decision maker simply to act impartially. There has to be justice seen to be done. And a party can challenge someone's appointment on the basis of apparent bias. That was the basis of the challenge in this case. The test for apparent bias is whether a fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased. There was no suggestion in this case that the arbitrator would be biased, but there was concern that his appointment in a number of serial arbitrations could give rise to a concern on the part of one or more of the parties as to unconscious bias or apparent bias. What the Supreme Court held was that in such cases, disclosure should be given of facts and circumstances which would or might give rise to justifiable doubts as to the decision maker's impartiality. So there was a positive duty to disclose. More importantly, for those of you who are adjudicators or involved in adjudication, the Supreme Court held that the mere fact that an arbitrator accepts appointments in multiple references concerning the same or overlapping subject matter with only one common party does not of itself give rise to the appearance of bias. However, it is something that must be disclosed because the inequality of knowledge between the common party and the other party or parties has the potential to confer an unfair advantage of which an arbitrator ought to be aware. It must depend on the circumstances of the particular arbitration, including custom and practice in arbitrations in the relevant field, which have to be examined closely. So what the Supreme Court was saying was that the mere fact that someone has been appointed in a number of serial arbitrations with one common party and a number of others doesn't of itself give rise to apparent bias, but it must be disclosed to the parties, and in certain circumstances it could give an unfair advantage that might amount to an unfair advantage, which could give rise to apparent bias. So the message is to those adjudicators who get serial appointments, please disclose the serial appointments and avoid a trip to the Supreme Court. Thank you.
Thank you very much indeed, Finola, for that enlightening talk. I was particularly interested in the comment about the potential future of adjudication enforcement being by way of virtual hearings. I can certainly see a lot of advantages to that. And also the Halliburton case, some people are absorbing that now, and yes. I think you did your words of wisdom there on that, because it really is very important that where there are serial adjudications, that adjudicators on our panel do disclose that. I'm aware from cases I'm dealing with, and when I assess adjudicators, that how common it is for there to be serial adjudication. Yeah. So thank you very much indeed for emphasising that point and really drawing that all to our attention. I think
could I just say very quickly, generally speaking, when disclosures are made properly and in advance, most parties don't have a difficulty with it. And of course, in terms of adjudication, there are good reasons why one adjudicator might have a number of very similar appointments, because that adjudicator may have a specialist knowledge that the parties want and the experience of dealing with similar types of cases. So I don't want to sound alarm unnecessarily, but it is the fact that the best line of defense for an adjudicator is to disclose fully and disclose early.
Absolutely, and we all know that the sort of disappointed parties will often, I think the phrase, was it Mr. Lord Justice Coulson said, scrabble around in the undergrowth looking for any reasons to avoid compliance, and will look for it for virtually any reason, and even if it's ultimately unsuccessful, it just wastes a huge amount of time and costs. So, so I think those are very wise advice indeed. I think in terms of timing now, we've come to 9:30. In terms of any questions, just to remind people to use the Q&A function. The chat function is disabled. So if you do have any questions for our speakers, just use the Q&A function. Finola, thank you very much indeed for taking time to speak to us today and to give us valuable guidance. I do hope that you'll be able to join us again at future conferences. But thank you very much indeed, and I'll let you get back to your busy caseload. Thank you very much indeed. Our next speaker this morning, we have Zoe De Corsi Arbiter. I'm sure many of you know Zoe. She acts for many of the leading contractors and other companies in the UK and abroad indeed, in dealing with construction disputes. Obviously this year, COVID-19 claims on the construction contracts has been a very hot topic. So we thought it would be useful to get an update from Zoe on the latest thinking and trends on claims relating to COVID. Over to you, Zoe.
Good morning. Thank you very much, Andrew, and thank you very much to you all for joining today. I've just had a tech support flash up on the screen. Can I just check that you can hear and see me okay?
I can hear you fine, Zoe, so I assume everyone else can. Thank you.
Okay, jolly good. Well, it's traditional at this time of year to look back over the year and reflect on the trials, tribulations, and successes. However, for 2020, one might be forgiven for not wishing to do so, and instead rather to be looking forward to the socially distanced fireworks heralding in 2021 and the traditional Coca-Cola truck, this time interestingly rebranded with its new Pfizer armory. It's no doubt been an extraordinary year. I'm not going to use the word unprecedented, as I fear that might incite several of you to shout at your screens right now. But if you will indulge me for 20 minutes or so, I'd like to take you back to the beginning of this year to reflect on what the industry, and indeed we have all been through, and what we might expect going forward. I'm going to take you through what I have considered the 5 phases of the pandemic. Now, I've heard this expressed as 6, 7, 8, 9, or even 10 phases. And there's, of course, many different ways that one could subdivide those phases down further. But I tend to see them in about 5 phases at this stage anyway. And then look at 3 key areas of focus in terms of construction contract claims, before finishing with some look ahead thoughts. COVID-19 has, of course, been a global phenomenon. There are significant differences in government responses in different jurisdictions. Indeed, as we've seen even within the UK itself, the 4 corners of the British Isles have often pulled in divergent directions. The UK itself has enacted hundreds of laws, regulations, directions and guidance in response to the pandemic. And those often differ substantially depending on which part of the UK you're in, owing to public health being a devolved policy area in Scotland, Wales and Northern Ireland. Currently in England, there are two key items of primary legislation: the Coronavirus Act 2020, although I note Scotland has a few more, and the Public Health Control of Disease Act 1984. However, you may be interested to know that I did do a short internet search on legislation.gov.uk, just putting in coronavirus in the title to see what came up. 574 statutory instruments and rules came up in that search. I have certainly not read all of them, but I thought you might be interested just to get a sense of the legislative environment in which we are currently operating. To actually understand what the working rules are, though, you need to look at both legislation and government guidance. And whilst it's clear that legislation sets out the legal obligations and restrictions that are enforceable in law, it is by far less clear whether guidance and advice can be said to be legally binding in any given situation. In short, the law is what we must do, but the guidance tends to be a mixture of what you must do and also what the government thinks you should do. And no doubt the extensive guidance in the UK at the moment causes significant uncertainty in respect of contractual rights and obligations, which I will come on to look at in the context of construction cases. To add to this complexity, what we've seen is legislation being frequently amended by subsequent legislation, or guidance being frequently amended by subsequent guidance. So as a result, it is probably correct to say that most people now look at the COVID-19 response in phases, as legislation and guidance has changed over time. And I think we all know we're unlikely to get to a settled position for some time yet. There are very different ways of cutting the cake on this. My key 5 phases are as follows. Phase 1. January to March, or as I like to think of this phase, the out at sea phase. How long ago it seems that we were all watching The Diamond Princess and its struggles. In January of this year, the government had its first COBRA meetings in response to the coronavirus threat. We were told the NHS is well prepared, but that the Foreign Office had advised at that time against all non-essential travel to China. Then the WHO declared public health emergency of international concern. And by the end of January, we had the first confirmed cases in England. In February, the government introduced legal powers to impose restrictions on individuals who risk spreading COVID-19, the Health Protection Coronavirus Regulations. And we started to see a raft of guidance starting to be brought in to address safe working in the workplace. By March, the government had published its COVID-19 battle plan and its COVID-19 emergency bill. And critically, on the 11th of March, the WHO declared COVID-19 to be a pandemic. During this period, we saw rapid and significant change. We saw social distancing, bans on mass gatherings, and advice against all non-essential worldwide travel. We had the Construction Leadership Council site operating procedures guidance also come in, and that went on to be revised multiple times. And I think as of last month, we were up to version 6 on that. As we know, the 23rd of March brought the first lockdown, stay at home, closure of businesses, closure of schools. And on the 25th of March, the Coronavirus Act was granted royal assent, and the Health Protection Coronavirus Restrictions Regulations came into force the day later. This brought with it widespread sweeping powers, restricting freedom of movement, gatherings, and had the bite of enforcement power. Phase 2 April and May, which I term the "we will meet it again" phase, as we remember the Queen deliver her landmark speech. Boris is hospitalised. Dominic Cummings takes his eye test road trip. But the big focus is all around the 5-pillar plan for testing and tracing. You may remember the Isle of Wight pilot, and the NHS contact tracing system goes live. We're told we need to satisfy 5 tests to get out of lockdown. Prime Minister tells us there will be a more significant return to normality in time for Christmas, and we start to see some preparation for the reopening of society. There was messages around going to work, staying at home, staying alert. I won't try and recount Boris Johnson's speech on that. But what we do see in the legislative context is a massive guidance coming in again, which are very much designed to try and reopen business. Phase 3, the summer, there's a relaxation of rules. There's a lot of guidance again coming in on how one works safely, travel restrictions being lifted with corridors, etc. We move from level 4 to level 3, but we start to see the introduction of local lockdowns. And if you recall, Leicester was the first area to go into that. We also see amendments being made to the health protection regulations, bringing in a new offence of being outside of the place a person is living without reasonable excuse. There are soundings from the economy, and we're announced to be in a recession, having seen a 20.4% fall in Q2 of 2020. However, by September, the kids are allowed to go back to school, much relief for many of us, but by the end of September, we are back up to level 4. The rule of 6 is in, and we've got a 10 p.m. closing time on hospitality. Phase 4, October and November, which I like to think of as the King of the North phase in the unlikely candidate for that, Andy Burnham. The Coronavirus Act 2020 was extended, but Parliament wanted to be consulted and given the vote on any significant national measures before they come into force. So we see some more checks and balances being put in place. We're now at this stage up to version 6 of the site operating procedures, and we have a 3-tier regional system which comes into England on the 14th of October, with again stiffening up of restrictions and enforcements and fines for businesses for flouting them. As we know, this system was somewhat swiftly replaced by national lockdown in England from the 5th of November. My final phase, phase 5, where we are now, from the 2nd of December, back into a regional tier system, which some may call lockdown by another name. So, why did I recount our rather painful year? Really just to illustrate the vast and complex changing environment we've experienced, particularly the legislative environment. And this, I think, necessarily means that construction claims are highly likely to vary over time. I would therefore invite you to consider what I'm about to say in relation to the 3 key areas of focus for claims against this ever-changing legislative backdrop. I think there's probably been significant focus on contractual treatment of claims in the following main areas: force majeure events and frustration, change, and thirdly, acts of impediment and prevention. I'll take each in turn. Force majeure. I think it's fair to say that in the early stages, much focus was placed on the question of whether COVID-19 is a force majeure event. In the common law, in the absence of an established force majeure doctrine, we are, of course, tied to the words of the contract. Taking JCT as an example, as you'll be aware, force majeure is listed as a relevant event giving rise to an extension of time, but not specifically a relevant matter. But what does force majeure actually mean? Well, we look to case law to answer this question for us, and you may now be well familiar with the definition in Liebau-Pinn and Crispin, 1920. And that was this: the term is used with reference to all circumstances independent of the will of man, and which is not in his power to control. Thus, war, inundation, and epidemics are cases of force majeure. The argument therefore followed that as the WHO had declared COVID-19 a pandemic, which was by its very nature worse than an epidemic, it must be a force majeure event, and in JCT language, a relevant event giving rise to an extension of time. Taking NEC, that naturally adopts different language, but it too recognises that if an event occurs which stops the contractor completing the works either at all or by the date in the accepted programme, and that event was unpreventable and had such a small chance of occurring, it would be unreasonable for it to have been allowed for, then the project manager must instruct the contractor on how to deal with it. However, even if both contracting parties agree that COVID-19 is a force majeure event or a prevention event, there often remains disagreement around what this means in terms of contractual relief, if any. Back in June, if you attended the debate my colleague Stuart Thompson and I did on contractor claims, you may recall Stuart talking about the ripple effects, and he asked the question what the actual effect of the force majeure event was. Did the delay caused by COVID-19 impact the completion date? Did it cause the site closure if that occurred? And what were the consequences on the availability of resources, materials, and productivity on the programme? Now, these are all naturally very fact-specific questions and difficult to resolve. The answer is no doubt rooted both in the contractual terms being looked at, but also in the factual matrix of the actual case. It's also particularly difficult to resolve these things during the bumpy course of an ongoing construction project, where focus may well be placed or rather on mitigating the impacts of the ever-changing environment. But I think what we can say with some certainty is that the discussion around causation is very much likely to remain a hot topic of debate. My second area is change. Now, we may all well have seen rather too much change for 1 year, some good, some bad. In the legislative context, there has undoubtedly been significant change, as we have rarely, if ever, seen before. But in construction contract terms, the question largely centres around whether there has been a change in law which affects the construction works and methods of working, or whether those changes have arisen as a result of non-binding guidance, which may well not trigger relief depending on your contractual terms. It seems to me that this question can only properly be answered by looking at the specific facts of the case in question. I have outlined in my phases how things have changed dramatically over time, and it seems to me that it takes going back, looking at the facts of the case, and somewhat forensically plotting what change happened when, and considering the repercussions of those changes on the works and the construction methodology in play. Third, prevention. The other area around which there is significant debate is cognizant of their obligations in health and safety law, what, if anything, the contracting parties should have done in response to COVID-19 in terms of exercising their rights and responsibilities under the contract. By way of example, if you look at NEC Clause 19, this anticipates that a COVID-19 is an event which means the contractor is either unable to complete the works at all or by the accepted program date, an instruction should be given by the project manager. But again, what should the nature of such an instruction be? Should it be a change in scope? Should it be a change to start or stop work? Should it be a change to key dates? Was any instruction given? Should it have been in the circumstances of the case? When should the instructions have been given, and should have they been altered over the time? Again, all of these questions, the answer will rest in the facts of the case, and they are difficult to give any concrete answer to in a vacuum. So what next? Well, I wish I could sit here in front of you now and say, well, yes, this has all been figured out, and list off a number of cases which have decided these issues in any given context. I cannot at this stage. I can report that TECSA has had no adjudication notices which obviously refer to COVID in their dispute descriptions. And I think this somewhat generally accords with the feedback I've received from legal practitioners in the industry that whilst COVID claims certainly exist, they are as yet not going to formal dispute in any significant way. So I would say that it appears to me that we are in somewhat of a holding pattern on COVID disputes. And I gave some thought to why this might be, and I offer them up for your consideration. It may be, or it's certain, that the arguments are complex and the decisions may well be heavily fact dependent, set against the backdrop and the timeline of the phases that I outlined to you. I think the industry is firefighting to a certain extent. There is a lot of work being done to keep up with the demands of changing requirements and restrictions and mitigating further delay. In some cases, parties may be seeking to resolve their disputes amicably. There's an opportunity perhaps to do line in the sand deals, potentially including elements of acceleration to get projects back on track where possible. I think there is some effort being put into amending contracts to more clearly deal with force majeure events with clarity. And the final thought is whether there are perhaps other forums for dispute resolution, such as mediation, which are considered attractive. And for those of you that attended the debate that we did in June, you may recall Sir Rupert Jackson observing that there could well be a good role for mediators in resolving COVID claims. But I leave you with one final thought. This may well be the calm before the storm. We are heading into a period of significant economic uncertainty and downturn, amplified by Brexit on the back of COVID, and termination and insolvency risk do appear to be on the horizon. History tells us that economic downturn often provides a fertile breeding ground for disputes, and it may be the case that for those that are not otherwise capable of being settled, disputes will come into the foreground for decision in 2021, and they may well feature in TECSA's key cases of that year. I can hopefully end on a positive note, echoing Justice O'Farrell's comments, and say that the significant work which has been done to ensure that justice is delivered in a timely and fair manner, despite wholesale changes to working practices, the need to move to a virtual environment, through the careful use of technology, flexibility, and thoughtful dispute resolution procedures, puts the TECSA community, I think, in a pole position to respond to the challenges ahead. Thank you very much for listening today.
Zoe, thank you very much indeed. A characteristically clear and thorough review of the situation, much appreciated. Just looking at the any questions which are coming through. I suppose one thought I've had also is that I think wearing my sort of constructing excellence hat, I'm quite involved in the constructing excellence movement. It's been quite pleasing that there's been quite a lot of cooperation between contractors, employers and subcontractors. Certainly, whilst we've had lots of inquiries, as I'm sure you have, about how to resolve issues, the majority, they've seemed to have managed to work through issues. I've heard some suggestions that certainly if there's a government backed employer, if I can put it that way, they've tended to be a little bit more sympathetic to both time and money, but maybe on the private side, slightly less inclined to give money, but certainly time. I don't know if that's been your experience as well.
I think it's quite interesting because the government has taken quite a different approach with PFI operational contracts and actually come out and said it does not consider that it's a force majeure event, and yet provided a lot of guidance around what it's terming excuse me, responsible contractual behavior. So I wonder whether some of that responsible contractual behavior is what we are seeing across the public sector contracts. The private sector contracts, I think at the moment, my personal experience is, as you say, Andrew, they are parties are really trying to work together in many cases to resolve their issues. Everybody is vested in getting projects back on track. I do see that there's quite a lot of what I term line in the sand deals being done, parties coming together to look at the situation and see actually how can they work together to move the project forward despite this very difficult year. So that is encouraging. The only thing I would say is that inevitably there will be those disputes that just are incapable of being resolved. We have insolvency in particular in the industry looming its head again quite significantly, and so I don't think it's all going to be plain sailing.
Yes, I suspect you're right, and I know when we did have a discussion with Mrs. Justice O'Farrell, I think her prediction was that there would be a rise in cases probably next year. I'm aware of some adjudicators who are dealing with COVID-19 or claims, albeit we've not had a rush of them, as it were, by TECSA yet. But I suspect you're right. There will be more coming to the fore during the next 12 months. Thank you very much indeed, Zoe, and that's a very neat segue into our next talk. So I'm delighted that Sue Ryan, who's a partner at Gowlings, and again, who many of you will know Sue, been leading construction lawyer for many years, and she's very kindly made some time in a very busy diary. I know she's frequently working late at night, and she also does a large amount for TECSA, in addition to being on the adjudication committee, as indeed Zoe is as well. She's also membership secretary and also on the litigation subcommittee as well. So Sue is very much to the fore in terms of TECSA, and it should be perhaps pointed out that all TECSA committee members are volunteers, and they do this in their spare time. So I do thank Zoe, Sue, and the other committee members for the work that they do. We're running a little bit ahead of time, which is probably a fairly rare event in these types of events, but hopefully Sue will be ready to start in a second. I've had one question which has come in, which is from our chairperson, Caroline Pope, which is, could our adjudicators let us know if they have an adjudication which involves a COVID-based claim? As Caroline points out, it's not always clear to us when the notice of adjudication comes in. So if perhaps people could give their feedback through the Q&A function as to whether they are, as adjudicators dealing with COVID claims, that would be very useful to have that feedback. I see that Sue's slides have appeared on screen. Are you good to go, Sue?
I am.
Thank you very much. Over to you then, Sue.
Thanks, Andrew. Well, good morning, everybody. It's a year since I was talking to you about Bresco and insolvency, and just what you want to hear, I'm sure, on a Monday morning. So here we are again, and I'm looking at what has happened since Bresco. I'm also going to be doing my Chris Whitty impression by saying to Amelia, who's kindly managing this webinar process for us, next slide, please. So could I have the next slide, please, Amelia? Thank you. Let's start by looking at the developing case law. So almost a year ago from now, I stood here, although in person on that occasion, and spoke to you about the Court of Appeal judgment in Lonsdale and Bresco. And I concluded with, so what's next? Will the battleground be injunction or enforcement? Well, in the meantime, as we've just heard from Zoe, we've been in a global pandemic for the last 10 months. But here I am again talking about will the battleground be injunction or enforcement? So let's just have a quick look at how we've got here. In July 2018, we had the first instance decision in Lonsdale and Bresco, in which Mr. Justice Fraser granted an injunction preventing continuation of an adjudication by a company in liquidation, holding that there was no jurisdiction on the part of the adjudicator as a result of the insolvency. In January 2019, we had the Court of Appeal decision, which is what I spoke about last year, and there was an unanimous judgment, which was that although the adjudicator would still have jurisdiction where the claimant company was in liquidation, generally, such adjudication was an exercise in futility, save in exceptional circumstances. And on that occasion, the injunction was upheld, hence me saying that I left off this time last year by saying, are we looking at injunction or enforcement? So let's bring ourselves up to date. Next slide, please. In October 2019, we had the application of the Court of Appeal judgment in Bresco, and we had Mr. Adam Constable QC sitting as a recorder in the TCC, looking at what the exceptional circumstances were. And he decided that a case which is likely to fall into that exception would be where the following factors are satisfied, being where the adjudication will determine the final net position between parties, where satisfactory security is provided in respect of both the adjudication award and any adverse costs award in related proceedings, and that would obviously be a matter of fact in each case, and then whether there was any agreement to provide funding or security which should not or must not amount to an abusive process. Following the Meadowside decision, we had a decision of Mr. Justice Waxman in early 2020 in the case of Balfour Beatty versus Aztec Projects Limited. And again, Mr. Justice Waxman applied the factors set out in the decision of Mr. Recorder Constable and gave conditional leave for Aztec to pursue 3 adjudications, notwithstanding that it was in liquidation. and Balfour Beatty failed to obtain an injunction preventing Aztec from bringing those adjudication proceedings. Now, the key factors in that case were that the order would produce a final net position between the parties through the 3 adjudications, and there was adequate security in place. So I think we start to see the direction in which this is going. Next slide, please. So the Supreme Court judgment in June 2020 in the Lonsdale and Bresco case. And in their judgment, the Supreme Court allowed Bresco's appeal, deciding that an insolvent party could commence an adjudication. They looked at the fact that the problems caused by liquidation identified by the Court of Appeal in both Bresco and a much earlier case, Bouygues versus Dahl-Jensen, should be considered at the enforcement stage. So it would fall to the TCC to decide whether an adjudicator's decision in favour of an insolvent company should be enforced, and if so, whether a stay of execution should be granted. And there were various reasons sort of discussed for this, but mainly it went back to the position per Lord Justice Chadwick in the Court of Appeal, and he referred back to Bouygues and Dahl-Jensen and said the court is well placed to deal with those difficulties at the summary judgment stage simply by refusing it in an appropriate case as a matter of discretion, or by granting it but with a stay of execution. So no real change there other than the original position being restated. Next slide, please. So what now? Next slide, please. Thank you. First case to look at this in detail was an application by administrators to enforce an adjudicator's award in favour of a claimant company in administration, and this was successful. The dispute centred around the security offered by administrators, which was an offer of an after-the-event insurance policy covering £200,000 of potential arbitration costs for an arbitration to overturn the adjudication decision that might in course be ordered in favour of GE. And GE said that wasn't sufficient. But His Honour Justice Parfitt disagreed and said that there was no convincing evidence that had been put forward to justify an argument that £200,000 was insufficient. The adjudicator's award was enforced and summary judgment was given on the condition that the relevant sums remained ring-fenced until after the conclusion of any appeal process from the arbitrator's award, plus the £200,000 after the event insurance policy. So I think one of the reasons, or the reasons behind this, really were that the administrators had not sold or assigned the claim to a funder. They were actually bringing this action themselves on behalf of the creditors. And the administrators had offered to ring-fence the adjudication award sum of approximately £700,000. Next slide, please. And that brings us on to quite a big case this year with some interesting issues being heard. Now, because of the significance of the Lonsdale and Bresco case, Mr. Justice Fraser, who was the assigned judge for John Doyle, postponed the hearing of this case until after the Supreme Court judgment was issued in Bresco. So to start with a bit of background, this relates to a landscaping works contract at the London Olympic Park under an NEC3 subcontract back in July 2010. John Doyle Construction went into administration in June 2012 and voluntary liquidation in 2013. And the liquidators later effectively sold the claim between John Doyle Construction and Erith to Henderson Jones for an immediate payment and a share of any proceedings that would be recovered in due course. And the terms of that were that John Doyle Construction would get 45% of any net recovery. Now, this adjudication took over 6 months and was very detailed. And Erith had plenty of time to put their case in this adjudication. And I'm speaking here as the partner of the Bowling partner who acted for John Doyle in the adjudication. And you may want to know a bit in terms of merits here, obviously biased because it was my partner who's given me this information. But he said that despite Erith subcontracting all of the work to John Doyle Construction and being paid £17 million for the privilege of having subcontracted all of that work to John Doyle Construction, they only passed £15 million of that onto John Doyle. So the £2 million shortfall for John Doyle was pocketed by Erith, and I think most of us would agree that's quite nice work. So that's a bit of anecdotal background anyway. Moving on to the actual enforcement hearing. Next slide, please. So John Doyle Construction had claimed £4 million in the adjudication and was awarded £1.2 million in a corrected decision issued in June 2018. And this 2020 application was to enforce that adjudication decision. And security was offered to Erith by a letter of credit and after the event insurance to ensure that if any potential repayment might be required in the future as a result of any substantive proceedings. Next slide, please. Now, ultimately, Mr. Justice Fraser did not enforce the adjudicator's decision, and he didn't enforce it because he said that John Doyle Construction had provided inadequate security for Erith's cross claims and also for Erith's costs. He considered the application with three key issues. The first being, in what circumstances will a company in liquidation be entitled to summary judgment on an adjudicator's decision in its favour? Secondly, are those circumstances present here such that JDC is entitled to summary judgment? And finally, if the answer to the second issue is yes, should the court consider a stay of execution in the light of the Supreme Court decision in Bresco and applying the principles from Wimbledon and Vago back in 2005? And in terms of precedent here, Mr. Justice Fraser noted that the Bresco Supreme Court judgment concerned whether a company in liquidation could adjudicate at all, rather than whether it could obtain TCC enforcement, although he acknowledged that although guidance is provided on enforcement, that isn't the central plank of the case before me, nor is it materially relied upon by either party. It is, however, an obviously important decision and must be considered in detail. So let's do that. Next slide, please. So issue one, the circumstances. Mr. Justice Fraser identified 5 principles. He said, had the adjudicator considered the entire financial dealings between the parties under the construction contract? Were there any dealings between the parties that were outside the realms of the construction contract? Were there any defences that were not deployed in the adjudication? Is the liquidator prepared to offer appropriate undertakings such as ring-fencing the enforcement sum and/or any other security? And is there a risk that enforcing the decision will deprive the paying party of security for its cross-claim? Next slide, please. Mr. Fraser then concluded that where a company in liquidation may be able to enforce an adjudication decision in its favour, the following applies. That the adjudication would have to resolve or take into account all of the different elements of the overall financial dispute between the parties to the construction contract. If there were mutual dealings on other contracts or other defences, if they've not been taken into account by the adjudicator, then they will be taken into account by the court on the summary judgment application, and that there should be no real risk that summary enforcement of the adjudicator's decision would deprive the paying party of its security for its cross claims. So, moving on to issue 2. Are those circumstances present here? Well, here the dispute related to JDC's final account, and that obviously encompassed all financial dealings between the parties. And Mr. Justice Fraser noted that the mere existence of some cross claims, which might be of relatively insignificant value, does not of itself mean that a claimant ought to be denied summary judgment. And then, did the draft letter of credit and after the event insurance policy offer sufficient security to Erith? Next slide, please. On this point, Mr. Justice Fraser concluded that the primary concern in terms of security related to the substantive sum awarded by the adjudicator, and that the costs of enforcement and any subsequent proceedings are a secondary concern. And he said, following the Medicide case, as near as possible, the safeguards must seek to place the responding party in a similar position to if the company was solvent. Now, in this case, he held that the proposed arrangements, being the letter of intent plus the after the event insurance policy, represented insufficient security, and therefore the application for summary judgment failed. And I won't share with you the follow-up to the decision by John Doyle Construction and the party whom had bought the claim from it, because they felt that that was a very unfair decision. And we'll obviously have to wait and see whether that kind of decision, that a letter of intent plus an ATE policy will be regarded as insufficient security, or whether the general thrust will be that an ATE policy is sufficient security, as mentioned in the case that I talked about before this one. Just one point that I'd like to share with you, because we are obviously here at a TECSA conference. Mr. Justice Fraser made a comment in the final paragraph in his judgment in John Doyle, which I'm just going to read to you. And he said, "The cases such as this one, with proceedings brought by a company in liquidation concerning a historic dispute so many years in the past, the normal timescales in the civil procedure rules for acknowledgement of service and other steps necessary for applications for summary judgment are likely to be more appropriate, with little justification for expedition. This will lead to hearings taking place within a number of months rather than within a few weeks of issuing the claim form. But this will have two advantages. The first is enabling a defendant to meet the claim for summary judgment fairly. More may be required by way of evidence than the usual fare on conventional adjudication enforcement by a solvent company on a more recent dispute. The second advantage is this will preserve the fast track process for those solvent parties who are in urgent need of a decision from the court on a more contemporaneous or pressing dispute. Changes to the TCC guide are usually achieved by consensus with the TCC Users Committee, chaired by the judge in charge, and the professional users organisations, TECBAR and TECSA. This is a point that will have to be addressed, following the Supreme Court judgment in Bresco. However, parties in a position similar to that occupied by John Doyle Construction should not expect their claims for summary judgment to be routinely expedited in the same way as more conventional adjudication business. So I think there Mr. Justice Fraser was making his views clear in relation to the use of this sort of method of dispute resolution many years after the event. So the other thing I was going to mention here is that we will, as the TCC Users Committee and as chair of the TECSA Civil Litigation Subcommittee, I sit on that Users Committee. We are currently close to the final draft of a new edition of the TCC Users Guide, and Mrs. Justice O'Farrell will obviously be determining whether or not the TCC Users Guide should make reference to the decision in Bresco and what effect it will have on adjudication timetable. So back to the final point in in John Doyle. Next slide, please. So on whether or not a stay of execution should be granted, this part of the decision was obiter, but Mr. Justice Fraser said it can be seen that at 26E in Wimbledon and Vago, that it expressly stated that if the claimant is in insolvent liquidation, then a stay of execution will usually be granted. And so absent exceptional circumstances that would justify not awarding a stay of execution, the most that JDC could achieve would be summary judgment on the sum awarded by the adjudicator with a stay of execution, and there were no such circumstances here. So I think it's quite clear what Mr. Justice Fraser's view of this type of issue is. So moving on to a change in topic. Next slide, please, and a quick run through the Corporate Insolvency and Governance Act 2020 and its implications for adjudication. Next slide, please. I think that this is a piece of legislation which actually caught many of us, or most of us, on the hop in terms of how extensive its effect is going to be felt in relation to adjudication. So there is a new Part A1 moratorium which allows a company in financial distress breathing space, initially 20 business days, free from creditor action. This must be proposed by the company directors, and it commences once the relevant documents are filed with the court or on the date of the court order, and it lasts for 20 business days and is potentially extendable. Next slide, please. Now, the wording of the new Part A1 moratorium is no legal process, including legal proceedings, execution, distress, or diligence, may be instituted, carried out, or continued against a company or its property, except with the permission of the court. Next slide, please. So the big question for us is, does the Part A1 moratorium prevent adjudication? And I think that where we are with that is that it is likely to prevent a party referring a dispute to adjudication without first obtaining the permission of the court. And there are a couple of things that militate towards that. The first being that the wording of the Part A1 moratorium is substantively the same as that in the paragraph 43.6 of Schedule B1 to the Insolvency Act, which is the pre-existing administration moratorium. And then secondly, in quite an old case now, Strone versus Bradlaugh, in the context of administration moratorium, adjudication was decided to be a quasi-legal proceeding, and so was prohibited without leave of the court, which in that case wasn't granted. Next slide, please. So how will this impact adjudications which are already underway? Well, let's have a look at South Coast Construction and Iverson Road. This was a dispute referred to adjudication in September 2016 and a decision on 21st of November 2016. Proceedings were then issued to enforce the adjudication decision, and then in January, notice of intention to appoint administrators was issued. The hearing was fixed for the 18th of January to consider the enforcement application plus an application for permission to proceed with a hearing in view of the moratorium. And then on the 19th of January 2017, a liquidator was appointed early that morning. Next slide, please. Now, in Mr. Justice Coulson's judgment, albeit obiter, he said that as the company went into liquidation on the 19th of January, the moratorium had ended at close of play on the 18th of January. But if it had continued, then the court's discretion would have been exercised to allow the application to enforce the adjudicator's decision. So he was clearly coming out on the side of this being permitted to proceed. And next slide, please. I think that's because he feels that adjudication proceedings are unique in nature, and that what must be done is a balancing exercise, and that permission will be granted if the determination will assist overall resolution. He said that in this case, he'd taken into account conduct, and that there were exceptional circumstances as defined in AES, Barry and TXU, and that it was a substantive application which turned on one point only. So moving on to another aspect of the CIGA 2020. Next slide, please. Something which I think has really thrown everybody is the fact that termination provisions are dealt with in this new piece of legislation. Now, we'll all be familiar with the fact that many commercial contracts for the supply of goods and services contain termination clauses, and they do provide for termination in the event that a party enters into insolvency proceedings, or sometimes even if it's threatened. Now, typically a supplier will refuse to continue to supply the other party in an insolvent situation because they know they're not going to get paid, or they will use it as a means to try to obtain payment before they give any further supply. Now, there have been increasing concerns that these clauses prevent those in financial difficulty from engaging in meaningful insolvency procedures because the contract would just be terminated. So what the effect of the CIGA 2020 is that, next slide please, the Act states that in most contracts concerning the supply of goods and services, this type of clause will cease to have effect when the customer becomes subject to a relevant insolvency procedure. This is defined in the Act, but can include all manner of the different insolvency procedures, as you can see on the slide. And the provision's very broad and prevents a supplier not only from terminating, but also from doing any such thing because the other party is subject to an insolvency procedure. Now, there are some exceptions to this rule, including certain types of and size of supplier, and there's a real hardship exception, meaning that if that is going to cause the supplier real hardship, then it may still be able to rely on the provision. And so whilst the intention is to help companies trade through an insolvency process and improve chances of rescue, it has been acknowledged that these changes will clearly put the supplier at risk. And so I leave you with the thought on that of, is this going to be a fertile ground for future disputes? I think bearing in mind the number of insolvencies that we're expecting, as Zoe has talked about, and you know the way the economy is currently struggling, that we could well have a significant number of disputes relating to this type of issue and the interpretation of contracts. So next slide, please. And it's the last one, you'll be pleased to know. Next slide, please. The current position. So insolvency adjudication. The Supreme Court made it clear that the insolvency and adjudication regimes are not incompatible. And I think this is probably the fact that they took a common sense approach. Issues considered at enforcement stage will leave all the parties with the benefit of an interim binding decision. But where there's an insolvency moratorium in place, I think there's probably no automatic right to adjudicate, and the courts will have to consider this on a case-by-case basis, and we'll be looking at the balancing exercise between the creditors. And as I've said, we're expecting that there will be far more insolvencies and therefore far more insolvency moratoriums going forward, given the economic climate that we're in. So that's all from me. I do hope that this time next year, I'm not still talking about insolvency and adjudication, but I'm not sure that I can guarantee that. Thank you.
Thank you very much. So yes, I wouldn't bet on it. Yes, I suspect we'll be talking about insolvency for some time in the construction sector, unfortunately.
Maybe I won't be talking about it then.
Well, you do it so well, Sue, so we do keep calling you back to do it. So thank you very much indeed for that very clear and thorough presentation. One question has come in. I don't know whether you want to have a couple of minutes just to think about that, and then we'll pick that up at the end if there's time. Would that work for you, Sue?
Yeah, that's fine.
And so what I'd like to do, and we've had a couple of messages through on the Q&A. So there's a question from Kim Teichman for you to have a look at, Sue, whilst Sharon's speaking. And we've had some feedback from panel members in terms of COVID. Interestingly, Francis Kirkham, Francis has issued a decision back in September on whether COVID-19 difficulties amounted to force majeure. So there may not be a flood of cases, but there certainly are some cases about. And we've also had some feedback from Charles Brown to say that whilst he's not had any COVID-specific disputes yet, he thinks that it has caused some backup of disputes that are now beginning to unblock, and I think that's probably a fair comment. So thank you for that feedback, and if there's any other feedback or questions, then please do send that through on the Q&A function, as the chat function on it for its webinar is just for the present presenters. Okay, our final talk this morning, I'm delighted to have Sharon Basrai, who's an associate at Pinson Masons, who's very kindly agreed to give us an update on some of the key adjudication cases of 2020. Over to you, Sharon.
Thank you very much, Andrew, and good morning, everybody. As mentioned, over the next 20 minutes or so, I'm going to address a few of the key adjudication cases of 2020, dealing firstly with an update on smash and grab, and then with a few other cases worthy of note. If I could have the next slide, please. Great, thank you. So smash and grab adjudication is very much alive and well. Now, it's probably the most common type of claim referred to adjudicators. Previously, we had the landmark decision in Grove and the first test of its application in Davenport. This year, there have been several more reported cases concerned with the enforcement of smash and grab adjudications. I will discuss 3 particular cases listed at the bottom of the slide there. They give a good indication of the court's current approach. We will see that this approach is a robust one. Smash and grab is a part of the statutory framework and will be enforced as part of the pay now, argue later principle. Moreover, stays of execution will seldom be granted. Next slide, please. Now in Grove, the Court of Appeal held that ISG versus CVIC had been wrongly decided. A smash and grab decision does not preclude the true value of the payment being adjudicated. But for the now well-known reasons given in the quote, Sir Rupert Jackson declared that a smash and grab adjudicator's decision must be paid before a subsequent adjudication about the true value of the payment can be started. Next slide, please. Now, in Davenport versus Greer last year, Mr. Justice Stuart Smith considered whether non-payment of a smash and grab decision really does prevent a party from commencing a true value adjudication. The judge acknowledged that the judgments in Grove clearly stated that a true value adjudication cannot even be commenced before payment of the notified sum. However, after reviewing the earlier Court of Appeal decisions in Harding versus Pace, he reached a different view, concluding that an employer, on the wrong end of a smash and grab decision, must discharge that immediate obligation to make payment before he will be entitled to rely upon a subsequent decision in a true value adjudication. So, somewhat different wording to Grove, suggesting that a subsequent true value adjudication can be started even before a smash and grab decision is paid. Next slide, please. My first case this year is a decision of Mr. Justice Fraser, Hopkins versus Trent. It strongly supports the pay now, argue later message, making clear that an adjudicator's smash and grab decision will be enforced provided it is made within jurisdiction and without any serious breach of natural justice. It also appears to support Mr. Justice Stuart Smith's view in Davenport that a true value adjudication can be started even before a smash and grab decision is paid. Now, the facts are summarised on the slide. Key points are that 6 months after its interim application 26, Hopkins started a smash and grab adjudication on the basis that Trent had not issued an effective payment notice or pay less notice. Hopkins was successful. However, Trent failed to pay, and so Hopkins applied to court to enforce the adjudicator's decision. Now, by this time, the parties had proceeded to interim application 33. Trent resisted enforcement of the decision, seeking a stay on the basis that Hopkins was no longer entitled to be paid the sum due under interim application 26, as any entitlement under that application had been superseded by subsequent interim payment cycles. Trent also started a true value adjudication before the enforcement hearing. Next slide, please. Trent argued that enforcement of a smash and grab decision on interim application 26 would be inconsistent with the correction principle, namely that interim payments can be corrected in subsequent payment cycles. The judge disagreed. Whilst the judge acknowledged that where failure to serve notices in response to an interim application results in the applied for amount becoming due, that could be corrected in later interim payment cycles and in an adjudication about true value. That all followed from the decision in Grove. But he said that that does not lead to the result that the original amount due was somehow cancelled out. As a party may refer a dispute to adjudication at any time, subsequent payment applications do not cancel out disputes on earlier ones, even if just on a technicality, such as lack of notices, nor does an estoppel issue arise. So the amount held due on interim application 26 remained to be paid. The summary judgment was therefore granted to enforce the adjudicator's decision, but should a stay be ordered? Next slide, please. Trent had applied for a stay of enforcement, but not on the usual grounds of inability to repay or intention to dissipate assets, but to prevent manifest injustice. Reliance was placed on the decision in Galliford Try versus Astuda, where Judge Edward Stewart granted a partial stay on some of the amounts awarded by an adjudicator because, one, of the poor financial position of the paying party, and two, it would be many months before true value on the final account would be determined, assuming that is, ISG versus Civic was correctly decided. Now, Judge Fraser pointed out that ISG versus Civic had been overruled in Grove. Also, the facts in Astuda were very unusual. Here, in this case, there was no evidence about the precarious position of the defendant, and a true value adjudication had already been commenced. So, a stay was refused, and Judge Fraser made clear that manifest injustice is unlikely to be grounds for a stay in the future. Now, we'll return to this topic shortly. Next slide, please. So moving on then to the case of Broseley. This also concerned a smash and grab decision on an interim payment and an application to the court for a stay of execution. The dispute concerned a project to refurbish a property in Chelsea. Prime failed to respond to Broseley's interim application 19 by way of a payment notice, and the pay less notice served on its behalf was late. Broseley quickly obtained a smash and grab adjudication decision in its favour, yet Prime still failed to pay. So Broseley terminated the contract and applied to the court to enforce the adjudicator's decision. Following Broseley's application to enforce the decision, Prime conceded that it had no grounds to oppose summary judgment enforcing the smash and grab decision. However, Prime argued that if a proper evaluation of the final post-termination account between the parties was taken, there would actually be a substantial sum due to it from Broseley. Next slide, please. On that basis, Prime asked the court for a stay of 2 months in order to allow a true value adjudication to take place. Prime tried to distinguish Grove, contending that it was permitted to commence such an adjudication without paying the amount in the smash and grab decision because the true value to be adjudicated would be of the post-termination final account, whereas the adjudicator's decision had been about interim application 19. Next slide, please. The judge held that to allow such an adjudication without prior payment would be a remarkable intrusion into the principles established in Grove. It would permit the adjudication system to trump the prompt payment regime, which is exactly what the Court of Appeal said would not be permitted to happen. The judgment also indicates that this judge considered the commencement of a true value adjudication, even on the final account, is not permissible prior to payment of a previous smash and grab decision on an interim payment. This, however, does seem a stretch too far. Importantly, the court here did not review last year's carefully considered judgment in Davenport. Next slide, please. Prime's application for a stay of execution for the entire judgment sum, pending the determination of the true value of the final account, was also based on the assertion that it intended to issue court proceedings as to the true value. But, crucially, Prime had not commenced such proceedings at the time that the application for a stay was heard. The court accepted that there was a genuine dispute as to the final account, but too long a period had passed since the adjudicator's decision, during which time Prime had done little to seek to resolve the true state of the accounts. This was a crucial factor. The judge referred to Coulson on construction adjudication, which states that a failure by the defendant to pursue its cross-claim or challenge with diligence may itself be a bar to a successful application for a stay of execution. The court found that the matter here was exactly the type of case caught by that reference in Coulson, and a stay of execution was refused. Next slide, please. Now, in October, a smash and grab case was decided which prompted headings like these in the legal press and on various law firm websites. The case was JRT Developments versus TW Dixon Developments. The headline writers may potentially have exaggerated just a little. There really is, unfortunately, no general get-out-of-jail card for paying parties who do not serve a payment notice or pay less notice in response to valid applications. Next slide, please. The facts in this case are important, as they were rather unusual. The employer was a company set up by the Dixons, an elderly couple with no prior experience of construction, to develop 14 houses on land that they owned. JRT, the contractor, was set up by the couple's nephew. Although he was a quantity surveyor, this was JRT's first major construction project. Dealings between the two parties during the project were rather informal. JRT helped Dixon in ways that would not normally be expected of a contractor, for example, with funding arrangements. And the relationship between the two was more akin to JV partners. There was a JCT contract between the parties, but neither operated the payment procedures specified. Payments were made by periodic drawdown from a loan. The relationship, however, soured as a result of cost overruns and delays. Both parties subsequently alleged the other was in repudiatory breach of contract. Next slide, please. Following termination, JRT, the contractor, issued a payment notice for a gross valuation in excess of £3 million. However, it should be noted that an independent valuation carried out for the project's funder of the works was just £2.1 million. Dixon did not appreciate the significance of JRT's payment notice, which was the first one issued on the 3-year project, and so they did not serve a pay less notice in response. JRT quickly obtained an adjudicator's smash and grab decision. Dixon argued that the payment notice, which sought payment of approximately £1 million, was grossly inflated and that JRT had already been overpaid. Dixon therefore refused to pay the decision. JRT responded by issuing enforcement proceedings. Now, Dixon conceded summary judgment, but sought a stay of enforcement pursuant to Rule 83.7, Subclause 4 in the Civil Procedure Rules on the basis that there were special circumstances. And, importantly, Dixon immediately commenced Part 7 proceedings to have the true value of the account assessed. Next slide, please. 2 special circumstances were relied upon by Dixon to stay enforcement, and Dixon was successful on both grounds. The first was that Dixon satisfied the Wimbledon tests in that, 1, it was highly probable that JRT would be unable to repay the judgment sum if ordered to do so after the Part 7 proceedings. 2, JRT's financial position was substantially worse than it was when it had entered into the contract. 3, JRT's financial position was not caused wholly or in significant part by Dixon's failure to pay the sums awarded by the adjudicator. The court therefore granted a stay of execution of the enforcement proceedings pending the court proceedings on the true value of the account. Importantly, those Part 7 proceedings had been issued by Dixon very promptly. The second and more interesting special circumstance was the manifest injustice that would otherwise have arisen. The principle of manifest injustice, as I mentioned, established in the Galliford Try case, is a rare exception to the general rule that adjudication awards will be enforced. The court here applied the Galliford Try decision, concluding that there would be manifest injustice to Dixon if the judgment was not stayed. Next slide, please. In considering the concept of manifest injustice, the court looked in detail at the background facts, including, firstly, that the payment terms of the JCT contract were ignored by both parties throughout the project. Secondly, the court considered the tactical nature of the payment notice. This was the first notice issued several months after termination and was designed to trigger a smash and grab. Thirdly, the merits of the case. It appeared that the sums in JRT's payment notice were grossly inflated, with items included which were otherwise irrecoverable under the contract or at all. Fourthly, Dixon could not pay the adjudication award, and if compelled to do so, would immediately be insolvent and forced into liquidation. Lastly, funding arrangements agreed separately indicated that JRT would be paid only by funds from the funder and then proceeds of house sales. On this basis, the court exercised its discretion to grant a stay in these exceptional circumstances to prevent manifest injustice to Dixon. Next slide, please. So, how often will the court grant a stay of execution to avoid manifest injustice? In the first case that I discussed, Hopkins versus Trent, Judge Fraser emphasised that to use the concept of manifest injustice as a means of examining the supposed merits of the underlying dispute would undermine the policy of enforcement of adjudicators' decisions and the purpose of the Act, and thus the intention of Parliament. That is a very clear signal. Surprisingly, the court in JRT appears not to have considered the Hopkins versus Trent judgment. So, despite the JRT decision, manifest justice will seldom rescue a party that has lost a smash and grab adjudication. Next slide, please. In summary then, and to conclude, my key takeaway points are as follows. Payment and pay less notices remain critical, particularly in the current economic climate. If the payer fails to serve one of those notices, a smash and grab adjudication is very likely to follow, and the court will usually give judgment to enforce it. The payer can probably start a true value adjudication in the meantime before making payment, but will not be able to rely on the result until it has paid the previous decision. Moreover, the court will not be easily persuaded to grant a stay of execution, and manifest injustice will seldom be relevant, only perhaps in the most exceptional circumstances where the payer is unable to pay, it is patently clear the merits are on its side, it has acted quickly to challenge the decision, and the Wimbledon tests are satisfied. Next slide, please. I will now move on to another few cases worthy of note. Those are listed on the slide here, but due to time, I will only address the first two listed. Next slide, please. Starting firstly with MW Heideck regarding a no crystallised dispute jurisdictional challenge. Whilst this is an argument which is often made in adjudications, it's usually as a bolt-on to another challenge and not one we often see reported in the judgments from the TCC. The facts in this case are as follows. Balfour Beatty served 5 notices of delay between March 2018 and February 2019, as required by Clause 2.17 of the parties' JCT design and build subcontract. High-Tech, however, did not respond to those notices or request further particulars to support the extension of time claimed within the 16-week period specified under Clause 2.18 of the subcontract. A few months later, in July 2019, Balfour Beatty served an expert's report, the Goodman Report, that included a critical path analysis and sought a response to its claim within 7 days. However, no response was forthcoming, and the dispute was referred to adjudication. High-Tech contested jurisdiction on the basis that the Goodman Report was a new analysis containing, amongst other things, references to a new relevant event, and therefore the contract required a 16-week period for such matters to be digested before it could be said that a dispute had arisen. The adjudicator rejected this jurisdictional challenge and awarded Balfour Beatty the full EOT claimed. High-Tech instigated Part 8 proceedings, seeking a declaration that the adjudicator did not have jurisdiction due to the dispute in question not having crystallised. Next slide, please. The question for the court was whether the Goodman Report constituted a material change, and, if it did, whether that reset the requirement for a decision to be made on the claim within 16 weeks of the received particulars. Next slide, please. Mrs. Justice O'Farrell considered whether the additional notification, when objectively assessed, was such that it gave rise to a new claim. At 51, Mrs. Justice O'Farrell states that if the additional notification did not change the fundamental nature and basis of the claim, the contractor would remain under an obligation to respond within the time frame set out in Clause 2.18. However, if the additional information objectively assessed gave rise to a new claim, the contractor would be entitled to a fresh 16-week period to consider such new claim. Next slide, please. On the facts, she held that it did not. The Goodman Report's detailed critical path analysis and the total extension of time claimed was marginally longer than the previous cumulative extension claimed, but it was not materially different to the delay claim advanced in the earlier notices. Next slide, please. So as ever, this decision turns on the particular facts of the case, but it is a very helpful reminder that it remains difficult to make out a no crystallized dispute argument. And while such a jurisdictional argument may be raised in an adjudication for tactical reasons, parties should be aware that it is unlikely to be successful in the majority of cases. Next slide, please. Just conscious of time, so moving on very swiftly to a natural justice argument resulting from COVID-19, a case which Mrs. Justice O'Farrell touched upon earlier, Milchrist Developments versus Waters. Here we saw the first case come to the TCC addressing the effect of the pandemic on adjudication procedures. The adjudication had been commenced by Ms. Waters, a homeowner, for the recovery of a £45,000 overpayment to the contractor, Milchrist. Having been granted a week from service of the referral to serve its response, Milchrist wrote to the adjudicator, arguing that it was not possible to comply with the timetable. It requested that the proceedings be postponed until after the lockdown measures were lifted. The adjudicator refused a postponement, but proposed a 2-week extension to the timetable. Milchrist refused and sought an injunction from the TCC to prevent the adjudication going ahead. Next slide, please. The application was heard on the 2nd of April. And at the outset, Justice Jefford confirmed that injunctions ought only to be granted very rarely and in very clear-cut cases. So, did Milchrist's case meet those criteria? Next slide, please. Whilst Milchrist had touched on jurisdictional objections, its submissions were focused on the argument that there were exceptional circumstances which meant that an injunction would be granted. The court examined the facts and applied the principles set down in the American Cyanamide case. Justice Jefford wanted to establish whether there was a serious issue to be tried as to whether the adjudication would be conducted in breach of natural justice, with the inevitable result that any decision would be unenforceable, adding that it would be wholly exceptional and unprecedented for such an injunction to be granted. Next slide, please. Milchrist made a number of arguments in its favour, including, firstly, that its solicitor was self-isolating, secondly, that witness evidence would be needed, which was inhibited by the pandemic, and thirdly, that it did not have time to attend or instruct an independent surveyor to attend the site inspection which the adjudicator had directed. On the facts of the case, however, the court determined that the difficulties experienced by Milchrist were not caused by the pandemic. Next slide, please. In particular, Mrs. Justice Jefford noted that 1, papers could be scanned or transported, and 2, the difficulties contacting witnesses were simply a function of the short timescales in adjudication. 3, the court had little time for the solicitor's busy workload. 4, the court pointed out that the adjudicator had offered a 2-week extension, which would have enabled most of Milchrist's difficulties to have been overcome. And finally, the court rejected Milchrist's submission that it would be wholly unfair for a site visit to take place without a surveyor in attendance for Milchrist. There was no such right, and practical steps could be taken to address the absence. It is no surprise, therefore, that the court did not grant the injunction and determined that the adjudication should proceed. Next slide, please. The decision in this case does not mean that adjudication will not account for the pandemic, but, as many of you will already have seen, it will do so primarily by way of an application for a reasonable extension to the timetable. Adjudicators are likely to be, and have been, sympathetic to such applications, although lengthy extensions are less likely to be granted where the dispute has been going on for some time. However, hopefully, with the promising outlook on vaccines and the fact that we're all used to working virtually now, means that we will not see such cases in the future. Thank you very much for listening today.
Thank you very much indeed, Sharon. I really appreciate that really clear and comprehensive summary of some of the most important cases on adjudication for 2020. And we've just got a few questions which have come in. I know that Zoe needs to drop onto another call. So perhaps just in terms of some of the comments through Q&A, Zoe, would you like to come in on, I think there's been a couple of cases mentioned on force majeure. Would you like to comment briefly?
Yes, thank you very much, Andrew. And thank you, Simon Tolson, just for mentioning a couple of cases, Fibrila Air Travel and Just US Air and TECSA Total Oil. and new stream trading. These cases are not construction cases, however, certainly worth a read. For me, there's kind of two main points that I take away from those cases. One is it really does depend on your contract wording. The cases turned quite heavily on the wording of the contract. And it also, I think, justifies why many contracting parties in the construction industry are now looking back at their contracts and saying, well, look, does the contract adequately provide for what we are experiencing at the moment? Do we need to amend our existing contracts to bring that clarity in? And indeed, what are we doing going forward? How are we dealing with this for our new contracts? So I think that's the first thing. And the second point was one that I also made when I spoke earlier, and that was there's heavy emphasis on the factual matrix, and that key question being that was actually performance of the contract prevented by the epidemic. And that certainly goes back to when are we saying that the force majeure event occurred, if it did in fact occur, and what were the repercussions, or to use Mr. Thompson's phrase, what were the ripple effects? So that's all really I was going to mention on those two cases. I've also seen quite a lot of comments coming in around COVID cases being in the tracks, as it were, and I think that probably summarizes where our general perception is that we have these cases coming through. They're in the pipeline. They may not have got all the way through to a formal dispute resolution decision as yet, but they're certainly there and around in the industry and not likely to go away anytime soon. That was all I wanted just to say by way of closing, Andrew. Thank you.
Thank you very much, Zoe, and I do appreciate your time and appreciate you may need to drop out of the call now, so much appreciated. Thank you. There's been a couple of questions on insolvency issues and Sue's talk. One from Robert Stevenson: do you think insolvency practitioners, purchasing funds can come up with a formula that will satisfy the courts? And then another question on, is the right to suspend impacted? I don't know if you've got some thoughts on those points, Sue.
Yeah, I think that certainly insolvency practitioners or sort of litigation funders will come up with a formula that will satisfy the courts. I think the difficulty is it's going to be very much in tune with the circumstances of each particular case, as you can see from the two cases that I discussed this morning, which had different results. So I think sort of we're probably in similar territory as we were some years ago when we were looking at the effect of providing an after the event insurance policy on an application for security for costs. It's all going to be taken on the individual circumstances and particular policy or security provided at the time. So that's that one. Is the right to suspend impacted? I'm not sure how it would be impacted, in that obviously the right to suspend is in the statutory rights to adjudicate and to suspend for non-payment. And I think we're talking about a different context here when we're talking about termination provisions on insolvency. So I think maybe I'm going to take the position that was taken by Mr. Justice Fraser originally on adjudications and insolvency, and said they're two different regimes, and I don't see why the right to suspend would be impacted in these circumstances. But only time will tell, I suppose. I did notice that Chris Ennis has made, well, numerous comments and points on the talks this morning, but one that's, I think, likely to be of interest to everybody, which was in relation to my comment about adjudication relating to insolvency being fertile ground. One difficulty that he's experienced in the past year as an adjudicator is the inability of either party to pay the adjudicator's fee, where the successful claimant depended on a win to be able to pay the fees. And the insolvency of the losing party brought the whole house down, as it were. And I don't know if I can sort of pose a question generally to our adjudicators, which is, you know, how would they feel if they were asked to be adjudicator now in a dispute where one or possibly both parties, you know, are in financial difficulties, or you know, there is a party in administration, obviously subject to first having got permission of the court.
Yes, I imagine there's been some who probably, yeah, it's going to be a little bit careful about taking those cases on. I think the really important points coming out of your talk, Sue, also, I think the SIGA has been slightly sort of underreported, if I can put it that way. So I think our panel and members just, if they're not familiar with that already, then just to be aware of that in terms of the right to adjudicate if there's a moratorium, as you say, issues in terms of termination provisions, and also say there's a debate about right to suspend as well. So that's well worth reflecting on. That piece of legislation perhaps hasn't got the publicity it deserves. And I know when we looked at structuring today, we wanted you to bring that to everyone's attention. So thank you for that, Sue. I'm conscious of time now, it's about 6 minutes past 11. Just to wrap things up by saying the slides will be made available. They'll be on the website, and also we'll have a recording of today's session as well. It may need to be edited, of course, but there should be a recording of today's session as well. I wish I'd had that haircut organised before today. But thank you to all our speakers. First of all, can I say that takes up a lot of time to prepare for these talks, and obviously time taken out this morning. So thank you very much indeed to all our speakers. And thank you to you all for attending this morning and taking a couple of hours out of your busy day. So really appreciate your attendance. I hope that next year we will be able to meet in person and have the conference and indeed have the dinner. I know that Dominic Helps was gutted when we couldn't have that, so it was such a great event. So hopefully we'll be able to run that next year as well. So it just remains for me to wish you all a happy Christmas and a safe Christmas, and look forward to catching up with you shortly. Goodbye.